What is this? Uniform rules for the New York City Civil Court continued. If an order of restoration is granted, it shall provide that a new notice of trial be filed forthwith and the case be placed on the general trial calendar in its regular place as of the date of filing of the new notice of trial, unless that the court in its discretion orders otherwise. I think that's just supposed to say, unless the court orders otherwise. A copy of the order shall be served on the calendar clerk, and the case shall receive a new calendar number followed by the letter R. Any discontinued action, the attorney for plaintiff shall file discontinuance with clerk within 20 days after such discontinuance. Any party claiming a preference must apply to the court by making a motion in the motion part. If a preference is granted, the action shall be placed on the ready calendar for a date certain ahead of all non-preferred cases. Within 20 days of the filing of a notice of trial, if the notice of motion for a special preference is filed therewith, or within 10 days of the service of a notice of motion to obtain a preference, any other party may serve opposition to granting preference, and the party wanting the preference may within 5 days thereafter serve and file rebuttal papers. Judges are encouraged to order bifurcated trial of issues of liability and damage in any action of personal injury. All subpoenas and processes for examination of debtors and other persons, including garnishees in connection with enforcement of money judgments, shall be filed with clerk of appropriate motion part with proper affidavit of service at least 2 court days before return day. Within 5 days after action is recorded, clerk shall send to small claims defendant by first-class mail and certified mail RRR a signed notice bearing the seal of the court. In a small claims case, the notice listed in question 14 must contain the following paragraph. Note, if you desire a jury trial, you must, before a day upon which you have been notified to appear, file with clerk a written demand for jury trial and pay a jury fee of $55 and file an undertaking in the sum of $50 or deposit said sum in cash. A commercial claim may be brought by a corporation, including a municipal or public benefit corporation, partnership which has its principal office in New York City, association with principal office in New York City, assignee of any commercial claim to the restrictions set forth in the New York City Civil Court Act 1809-A. If after the expiration of blank, I don't know this one. Damn it. Proceeding under RPAPL shall be commenced in the housing part. A penalty action for an immediately hazardous violation shall be commenced by order to show cause, returnable within 5 days or within a lesser time in court's discretion. 17, what was the answer? Oh, if after the expiration of 21 days, 30 days in the case of commercial claim arising out of consumer credit transaction from date notice was mailed, the ordinary first-class mail has not been returned, defendant shall be presumed to have received notice of the claim. A signature may be made. A signature on a document filed electronically pursuant to Civil Rule 208.4 shall be made by 1. Autograph of the signatory on a hard copy that is thereafter scanned into a portable document format. Oh, that's what a PDF stands for. Who knew? Or by the signatory electronically affixing the digital photo image of his signature to the document. Except as required by statute, a formal pleading may be dispensed with in any case in which the party required to serve the formal pleading appears in person, so without an attorney. And an order to that effect may be entered ex parte. Any other party can move to modify or vacate such ex parte order. Rule 208.7. A defendant's time to answer may be extended by ex parte order once and no longer than 10 days past the original time to answer. Action stricken from the calendar may be restored to the calendar only upon stipulation of all parties, so ordered by motion on notice to all parties made within 1 year after the action is stricken. So whereas in Supreme and County Court, the parties can all stipulate to, put the case back on, get the case out of default status. This one says it has to be a stipulation of all parties so ordered. The clerk shall not accept a summons for filing in the New York City Civil Court when it appears upon its face that the proper venue is a county division other than the one where it is offered for filing. The clerk shall, 1. Stamp upon the summons the date of such rejection. 2. Shall enter the date of such rejection in a register maintained by him or her. Or 3. Shall enter the county division in which the summons should be filed. Okay, this says, this is Rule 208.9. The plaintiff in a class of designated cases shall request a PC within 45 days after joinder of issue. So that's interesting because so far in like the Supreme and County Court rules, I haven't seen any requirement that there be joinder of issue. In fact, I had a whole conversation about it tonight about, does there need to be an answer to request a PC? I don't think so. I think there just had to be proof of service in certain circumstances. But anyway, so in the New York City Civil Court, it says they shall request the PC within 45 days after joinder of issue. So after the answer or notice of appearance is served. Request shall state 1, title of action, 2, index number, 3, date of joinder of issue, 4, name, address, phone number of all attorneys appearing, and 5, nature of action. Shall be served on all parties and filed with clerk along with the stamped postcards. Court shall order conference, to be held within 45 days of the date of the request unless ordered otherwise. So another soft 45 days for this one. Okay, this says, this is Rule 208.9. The plaintiff in a class of designated cases shall request a PC within 45 days after joinder of issue. So that's interesting because so far in like the Supreme and County Court rules, I haven't seen any requirement that there be joinder of issue. In fact, I had a whole conversation about it tonight about, does there need to be an answer to request a PC? I don't think so. I think there just had to be proof of service in certain circumstances. But anyway, so in the New York City Civil Court, it says they shall request the PC within 45 days after joinder of issue. So after the answer or notice of appearance is served. Request shall state 1, title of action, 2, index number, 3, date of joinder of issue, 4, name, address, phone number of all attorneys appearing, and 5, nature of action. It shall be served on all parties and filed with clerk along with the stamped postcards. Court shall order conference, to be held within 45 days of the date of the request unless ordered otherwise. So another soft 45 days for this one. So they also have to submit postcards with this request for PC. The court shall generally order it. This is a soft 45 days. Soft 45-day rule here about when the PC has to be held within 45 days of the date of the request for PC. Oh God, I wrote so tiny there. It's so not going to come out. If the form is not signed by all parties, they shall appear at the conference and court shall make a written order at the end. Oh, and it also says that a JHO may preside, but interesting. Okay, so this next thing I wrote really, really tiny, so I don't know. I'm going to try to get it on the video. At any time after joinder of issue and service of a bill of particulars, the party to be examined or any other party may serve on all parties a notice fixing the time and place of examination. Unless otherwise stipulated, the examination shall be not less than 30 nor more than 60 days after service of the notice. If served by a party other than the party to be examined, the notice shall name the examining medical providers who will conduct the examination. If the notice is served by the party to be examined, such party shall, within 10 days, submit to the party to be examined name of medical provider. Any party may move to modify or vacate the notices within 10 days after, 10 days of receipt thereof, on the ground that the time, place, and doctor or doctor are objectionable. So either time, place, or doctor are no good. At least 20 days before date of examination, party to be examined shall serve upon the other parties copies of medical reports and duly executed written authorizations. Copies of the reports of the medical providers shall be served on all other parties within 45 days of the completion of the examination. Supplemental medical reports of newly discovered alleged injuries must be served within 30 days of discovery thereof, and not later than 30 days prior to trial, and shall specify a time not more than 10 days thereafter. Within 30 days after discovery thereof, and not later than 30 days prior to trial, and shall specify a time not more than 10 days thereafter, and a place where a further examination may be had. Copies of those new medical reports shall be served within 10 days after completion of examination. If any party desires to offer testimony of other medical providers, their medical reports shall be served on all parties at least 30 days before trial. Motions directed to the sufficiency of medical reports must be made within 20 days of receipt. Holy crap, this is a lot of time rules. A notice shall be published in the Law Journal of the call of the reserve calendars at least 5 court days before such call. The notice shall specify the calendar numbers of the actions to be called. If actions are put on the ready calendar that have never been on the reserve calendar, they shall be published at least 5 court days before the call of the reserve calendar. Application for date certain. A party, attorney, or witness is more than 100 miles from courthouse, party or witness in military service or some other hardship exists, case shall appear at top of ready calendar. 208.4-A. Only no full actions filed by health providers against insurance providers. Date of receipt shall mean date on which electronic transmission of such document is recorded. So no fault actions mean healthcare providers against insurance providers for car accident cases. Date of receipt shall mean date on which electronic transmission of such document is recorded at such address. No later than 2 business days after date of receipt, clerk shall make available by electronic means a confirmation of electronic filing, and this shall constitute the clerk's return of the copy for purposes of the Civil Court Act. When such action is commenced by electronic filing, proof of service shall be filed by electronic means. Summons shall state 1. County division. 2. Location of court. 3. Names of parties. Motion for change of venue shall be heard in county division of the court in which action was instituted. Plaintiff in class of actions designated by the fucking chief administrator shall request a preliminary conference within 45 days after joinder of issue. Clerk shall notify all parties the conference date must be within 45 days, unless court orders otherwise. Party that files the notice of trial and certificate of readiness, he shall also file proof by affirmation or affidavit with proof of service showing specific compliance with the preliminary conference order. 2.8.21. Objections to preference. 2010-5 Ds for rebuttal. Party filing notice of trial shall provide marked pleadings, bill of particulars, and a 208.27. 208.23. Actions may be... What does that say? Oh my god, I wrote so small. Actions may be something, field on, fled on, held on? The ready calendar for not more than 10 days. Held on, maybe. 202.9 sub F. Preliminary conference in certain classes of cases. Motions and actions to which this subdivision applies made before the PC may be marked off or denied unless good cause is shown why such relief is warranted before that time.